Oscar Pistorius will be released on parole this Friday. The Paralympian was convicted for the murder of his girlfriend Reeva Steenkamp back in 2013. Now, Pistorius was initially sentenced to 13 years for the crime. Upon release, Pistorius must comply with specific parole conditions up until December of 2029 when his sentence ends. Now, these include regular monitoring, participation in gender-based violence programs, and ongoing therapy for anger management. To unpack this further, we're joined by legal analyst Mpumelelo Zikalala. Very good morning to you. Thank you so much for joining us. As Oscar Pistorius leaves the Attridgeville Correctional Centre tomorrow, the general parole conditions will apply. Exactly what do these conditions entail?
Good morning to you. Basically, it's one of those basic ones where they are reminding him to say, remember that you are still a prisoner, you are still under our care. Hence, everything that has to do with what would happen inside the correctional services facility will still apply to you, meaning there's no alcohol in which you're going to participate in. There are no media interviews in which you are going to do or participate in. You're basically, for lack of a better word, under house arrest. We'll monitor whether you're able to comply with all these things. And the ones that you've stated earlier of saying attend these programs that have to do with your gender-based violence workshops and any other thing that has to do with the rebuilding of the, let's say, the morals of the particular individuals and getting them back into a state in which he can then be accepted within the community. So if there's non-compliance with any of those things, or it can be seen that there's been maybe Mr. Pistorius has left the jurisdiction in which he's stationed in, then it would have meant that he's broken his conditions and he must come back and serve within the prison facility.
The restriction of parolees from conducting media interviews, why is that not allowed?
I think it's twofold. The first one is, let's remind you that you're still a prisoner. So if you cannot allow a prisoner to participate in those things, then you must not do that. Secondly is then to say, we still need to monitor what is it that you are going to state about the correctional services facilities, about the men and women, and also about the victim that still needs to understand or to get acquainted to the fact that you are now a person who's free. And I say that in inverted commas because you're not in prison. You are allowed to go to certain places of entertainment, for example, even though you're not allowed to go to clubs, but you can go out to the field, go out to the mall and participate in what a family person will then be able to participate in, and even in certain instances be able to interact with friends just as long as there's no alcohol which is involved. So if you are going to allow a parolee to then say, go and conduct interviews in the same manner that you wish for, we are basically saying the status of you being a prisoner, the type of punishment that I wanted to punish you with has now been taken away, and you can do as free as you want. It's almost as if you are no longer a prisoner anymore. So I think it's one of those conditions that needed to be there, just to ensure that the person is reminded as to the current status and the importance of why they are serving this particular sentence in the first place.
He's still got around 5 years to serve this particular sentence. What were some considerations which needed to be made here? Because as far as we know, according to reports on what his legal team was saying, he was meant to be out of prison before Christmas.
Well, I think that's up to the parole board. Remember, the parole board would receive these type of reports from the supervisor that are within the prison to say, here's prisoner X. They've gone through the particular process of attending the consultations. We've conducted the victim-offender dialogue, and this is how we feel that the person is ready to be released on parole. Are there any other conditions that would like to attach to them? And then the parole board would sit and then discuss how things are going to be. In terms of the time which then the person is going to be released, it's absolutely to the discretion of the parole board. And I think for them, in this case, it might be in a sense of saying, we know the type of media attention which is going to be attached to this particular matter. So releasing him during Christmas or before Christmas is not going to be something which is viable. Let's rather wait up until the following year, and then you can be able to do that. Those are purely my suspicions, not something which is a matter of fact.
Yeah.
But what I do have a bit of a problem with, or maybe a concern, it almost seems as if the parole system is a tick box exercise. Once you've done the workshops, once you've gone through the victim offender, regardless of what the victim is saying, who, by the way, was sitting in court and listening to the sentence which was given to that particular individual and got some sense of relief and justice that is being conducted or being done, that it is a reasonable expectation that the person is going to spend an X number of years in prison. If that does not happen, then what do we say about the victims? Also, it almost seems as if their voices have been dimmed down or they're being cut off, and their participation in the whole process is simply just a tick box exercise. Whether they participate or not is not going to have any bearing because the person is going to be released. So it's one of the things which I think coming back to the legislative reform that needs to be done with this particular act, especially when it comes to parole, is something that needs to be looked at.
I do understand that in this instance, the victim's family was able to interact with Oscar Pistorius, but still not happy with him not completely opening up and being honest. How important is that bit of interaction with the victim and the prisoner?
That's exactly why I'm saying it's almost like a tick-box exercise. Because if I, the person that has suffered, I have lost a daughter, I'm not satisfied that the person is telling the truth. There should be some leeway that I should be given, or some assurance that the person is going to stay in prison up until that particular process, or they've spoken the truth. Remember, when the court arrived at a decision of saying that Mr. Oscar Pistorius is going to spend a number of years in prison, there were signs behind that particular sentence. There are factors that were looked at in even case law, for example, expresses in. And one of the two elements which are then looked at is that of the victim himself and also the community, which is us as South Africans. What type of message are you sending? Now, it's almost as if the correctional services of the parole board are now rewriting sentences for particular offenders to say, this is how we are going to spend your sentence, this is how the element of justice is going to be issued. And while the process is being made, the person who is the main ingredient and that particular sentence, I said that sentence loosely, is not considered, because at the end of the day, they are the ones that you should be saying, Mrs. Reeva's parents, you lost a daughter. Can we take into consideration your feelings? What are you feeling about this matter? If they are saying that we do not feel that this person is telling the truth, then you shouldn't be sent out of prison. That is why, by the way, you have such a high number of incidents of people that are released on parole that end up going back to prison, because it proves that there's no full proof or preventative measure that have been stated in this case to say, how do we prevent a person going through the parole process even though they haven't been reformed? Another aspect to that is to say the manpower which is then attached to correctional services of supervising these particular individuals, whether they comply or not. Is it a process in which the media will then alert correctional services and say, we saw one of your parolees drinking the other day, have you been monitoring whether they are there? Do they have the adequate resources to make sure that it's compliant? Is one of the things that should be looked at a later stage.
Yeah, especially if the family feels that he hasn't been fully rehabilitated, the victim's family, that is. We know that he's going to be assigned a monitoring official. What happens after his release? I know you've touched on this, but I'm trying to get to the part where, when it comes to him perhaps looking to get back into training and being an athlete, is there leeway for that? What considerations are made in that space?
Remember that official who's going to monitor him is in constant communication with the parole board, because at the end of the day, he's still a prisoner, and the department is still liable for him to make sure that he's able to comply and do all the things, the instructions that they've given to him as he's going to be released tomorrow. So if there's any instances in which certain of the rules can then be relaxed, it goes back to the parole board, the ultimate deciding body, and through their discretion, they'll then say, well, you can see that you are being rehabilitated, you are getting to a point or into a stage in which you can then be reintegrated into the community much more effectively. Let's allow you to have more privileges, which will then be attached to you. But you must remember, it's nothing else but privileges. So the minute you break them, the minute you show that you are ungrateful for those privileges being provided to you, that's when they're going to be taken away and you're going to revert back to the initial condition that you issued, or the worst case scenario, being sent back to prison. So there will be constant monitoring which is going to take place. The point which I came to earlier of saying that, do you have enough manpower and enough resources to make sure that there's constant monitoring? Are you going to have information which is sufficient in order for the parole board to make an informed decision as to what to do if there are certain transgressions that have taken place? Those are the type of things that ought to be considered by the department.
And when it comes to the details of his release and concern that it may be a security threat for him and others, how imperative is the confidentiality in that regard?
It's very imperative. He's still a prisoner at the end of the day, and the department cannot issue out intimate knowledge as to how things ought to be inside. So the only thing which is taking place, or which us as members of the public ought to be informed by, is to say this particular prisoner is going to be released. on this particular date. It's intimate details as to when and how is he going to be transported is something which is the intimate knowledge of the department and can only be shared with us, maybe with the consent of him if he so wishes. But if he then says, no, please keep these particular details intimate, if they are going to compromise the security of the department, then I don't think that they ought to share those particular details with us. I think, though, they should be shared with the family of Reeva Steenkamp, because they are part and parcel and they are important stakeholders when it comes to this particular matter.
Very well. Thank you so much for that analysis. Mpumelelo Zikalala, legal analyst there, speaking as Oscar Pistorius is set to be released from prison come tomorrow. Of course, it's a story we'll continue to monitor and bring you the updates throughout the course of the next hours and days.